course, this whole material which I've already circulated with the capstream, and you will be certainly receiving it in some time. All right. This is the material that I'm talking about. All right. So we've spent good amount of time in preparing this material. Is the screen visible to everyone?
Yes, sir.
Yes, sir.
All right.
Yes,
So
sir.
if you see, I have gone about in summarizing the entire syllabus of your Companies Act, LLP, General Clauses Act, Interpretation of Statute, FEMA, and a couple of amendments in about 84 pages. All right. If you see in the first page, we have clearly given what exactly is the relevance of each and every topic, what is going to be the relevance of every subtopic with your from your examination. Then if you see, this is the material that we are talking about, which has a quick summary. Interestingly, this summary has been made very section wise, crisp to the topic. Everyone, can you see the screen is visible? Yes?
Yes,
No?
sir.
No, sir.
Yes,
All right.
sir.
I will share it once for all. Let me know if you can see it. Visible?
Yes, sir.
Yes, sir.
Yes, sir.
So if you look at it, what I've done is section wise, each and every chapter, section wise, what each of those sections are pertaining to. I repeat, this is merely a summary. This is not to give you a glimpse of the entire, this is not to give you verbatim each and every word, but it is to give you a quick summary of the entire topic. That is the whole intent of this material. So if you look at it, section wise, chapter wise, we have made this material. After this, you will see somewhere in the fag end, all right, from page number 85 onwards, mostly, if you see, there is something called summary, which I have captured. There's something on in September 2024. ICI had come up with their recommendations on how to handle this entire paper. So I've brought that screenshot as well. How and what is their expectations from the examinations perspective, from your answer perspective. Apart from this, all the relevant updates and amendments which are applicable to you, all right, I have captured it here. Is the screen visible to everyone? Yes.
Yes, sir.
Yes, sir.
All right. So what I've done is I've gone about capturing all the relevant material, all the relevant amendments for your examination. There are a couple of amendments which have been brought in. The bill has been passed or not, that is still not certain. I will confirm that if that relevant amendment is applicable to you or not in the May attempt. Everyone with me? So I'm not sure. Right now, Lok Sabha and Rajya Sabha have discussed a couple of 16 or 12 odd topics. In that, Companies Act was supposed to be discussed. If there is any discussion, then there are few minor changes in the Companies Act. Whether it is applicable to you or not, that we will wait and watch until your ICI itself issues an amendment material on that. Clear, everyone with me? All right. So let's begin. 200% focus. Let's ensure we see section by section each of these topics. Just ensure that you're there here with me, and let me know if the screen is visible to everyone. Visible?
Yes, no, sir.
Yes.
Yes,
Now it's visible.
sir.
Brilliant. I repeat, this is a summary. This is just to give you a quick glimpse of the entire chapter. That's the whole objective of what we are going to do. 1 hour, 50 minutes that we spent. Let's ensure that we cover as much as possible. May not be everything that we have discussed so far, but we are going to see as much as possible. We are going to cover it. All right. So the first chapter from your syllabus perspective is preliminary. All right. Which talks about what all are the relevant. Yes. Which talks about what all are the relevant topics from your examination. In the preliminary, the first section is section 1, which talks about short title, extent, and commencement. Please note, this is the section which talks about when is your Companies Act going to be applicable. April 1st, 2014. I repeat, it's Companies Act 2013, but effective from 1st April 2014. Nothing to be written. Close all your books and just focus while I'm discussing. Nothing to be written. This material will be circulated with you guys. All right. Second, this section also talks about what exactly will be a situation in case if there is a conflict between the Companies Act and the respective act. Law is very clear. If there is a conflict, if there is any provisions which are inconsistent between the Companies Act and the respective act. When I say respective act, it could be a banking regulation act. It could be an insurance act. It could be Insurance Regulatory and Development Authority Act. It could be in terms of your Electricity Supply and Generation Act, or it could be any other special act which has been framed for the respective entities. Then any inconsistent provision, you have to follow your respective act and not Companies Act to the extent of that inconsistency. Where is this coming? This is coming from section 1 itself. Then you have section 2, which gives a list of all the definitions. I've told you time and again, please do not spend time reading each and every definition here. Might as well go read the respective definitions whenever you come across. After that, if anything is left over, you read from these 95 sections, whatever is left over. Clear, everyone? Because you have to play it strategically. You may not be able to remember all the definitions when you're reading all the 95 together. You will not remember. Not possible. I don't want you to waste time as well. What you will do, rather, read those definitions as and when you come across those respective topics. Example, deposits, you go back, read what is the definition of the word deposits. Where is it? It's all coming in section 2. Clear? Section 3 talks about, here, section 3 is talking about, there's one topic on limited liability, which we will come back. All right. Or rather, let me finish it right away. Companies Act says every company, the members will have limited liability. Reason being, your liability will be only to the extent of the amount which is not paid on the shares or the amount of guarantee which you have given, unless and until it is an unlimited company. Unlimited company, by default, it says your liability is going to be unlimited. But when is it going to be unlimited? Only at the time of dissolution, not today. Only when the dissolution is going to be carried out, at that time your liability will become unlimited. What do you mean by unlimited? Tomorrow, if anything goes wrong, sell your house, sell your kidney, sell yourself, bring in the money. Clear? Now, there are a few exceptions to this concept of limited liability then. Apart from unlimited companies are very rare. Limited liability is what is the main feature of every company. Limited liability, as the word itself says, liability will be limited. Limited to what? Limited to the amount which you have not paid on the shares. Or limited to the amount of guarantee which you have given that you will bring in tomorrow if required. Such companies are called guarantee companies, all right, where the liability is limited to the amount of guarantee. Law is very simple. Here, your liability is limited. Now I'm saying in these kind of companies also liability can become unlimited. How is it so? 5 important scenarios. All right. First one, where you've given wrong representations. Second one, you've gone ahead and incorporated a company by giving false information. Third, in the course of winding up, it appears that you've purposely done this entire company to defraud the creditors. Fourth, prospectus you've issued with an intent to defraud the applicants and you've given false information in the prospectus. Fifth one, in deposits, if you fail to repay and if it appears that you've purposely not repaid, then in all these cases, liability becomes unlimited. What do you mean by unlimited? Company and the person who starts the company are not one and the same in a normal scenario. Solomon versus Solomon. All right. But if the liability is unlimited, company and the person who started the company are one and the same. What do you call this? Lifting of corporate veil. All right. This is called lifting of corporate veil. 5 scenarios where liability becomes unlimited. Crystal clear with the concept. Then we go to section 464. Section 464 says, please note, whenever you're running in any association, any group of people, ensure that you don't have more than 50 people in it. Sir, partnership firm, not more than 50 allowed. Sir, LLP is an exception. All right. So in case if you want to run such association, you register yourself as a company. Sir, no, sir, I will not do that. I want to run it as a partnership firm itself with more than 50 partners. Law has clearly told, please don't do this. No, you have done it. Entire association is going to be considered as illegal. What do you mean by illegal? That entire group is illegal. Whatever business you've done is illegal. When it is illegal, it is null and void. All right. Are there exceptions? Yes. First exception, LLP. Second exception, HUF. Third exception, professionals. A group of professionals can come together and run a business. Even if it is more than 50, it is allowed. Even if it is more than 50, it is allowed. Are you with me? Everyone understanding? All right. So this is in case of, so there can be a question in examination. Partnership firm with 60 partners and it's a professional group. All right. They are rendering CA services. Is it allowed? Since it is professional, it is allowed. Everyone with me? Understanding the point? All right. Now what will happen if it is an illegal association? Something which is illegal is always illegal. Can I wind up an illegal association?
It should exist to wind up.
It should exist to wind up. Brilliant. All right. When it is not existing itself, how will I wind up? So what do you mean by it is not existing, sir? It is illegal. When it is illegal, it is null and void right from inception. Right from beginning itself, it is zero. When something is zero, I can't bring it back to zero. Are you with me? Understanding? All right. So can I, if there is a question in examination, can I wind up an illegal association? Answer is no. You cannot wind up an illegal association. Why? It never existed. It never existed. Are you with me? All right. So you cannot enter into contracts. You cannot sue any of the members. You cannot go ahead and register as a company subsequently. You cannot be sued by a member or an outsider as well. Very important, very interesting. Neither you can sue an outsider nor an outsider can sue you. Reason being, doctrine of public notice, doctrine of constructive notice. We have already spoken about that. MOA and AOA, the third parties should have read that. If they have not read that, that is their problem. All right. This is about illegal association. Am I fast?
No,
Able
sir.
to catch?
No, sir.
Yes, sir.
Able to understand
Yes, sir.
everyone?
Yes,
We are done
sir.
with the first chapter.
Yes.
Now going ahead with the second chapter. Incorporation of companies. All right. Now, what is this topic all about? Sir, we've understood the concept of company. Now we want to start a company. Section 3 talks about a company may be formed for all the lawful purposes. All right. You can form a company for a lawful purpose, but it has to be with certain members, certain persons who are going to subscribe to the memorandum of association of the company. How many members or how many persons? If it is OPC, 1 person. If it is private company, 2 persons. And if it is public company, 3 persons. Listen to me very carefully. I'm not using the word members. I'm using the word persons. Why? Because they will become the subscribers to the MOA. They are the first members. All right. Listen to me very carefully. I repeat, section 3 says, if you want to start an OPC, 1 person required. If you want a private company, 2 persons required. If you want to start a public company, 7 persons required. Everyone with me? So these 7 persons, 2 person or 1 person will become subscribers to the MOA. And once they subscribe to the MOA, your form of company can begin. In case of OPC, please remember there is another additional point called nominee who will come into picture. All right. A nominee will come into picture if it is an OPC. Next point. What types of companies can exist based on liability? Company limited by shares, company limited by guarantee, unlimited company. Just now we have discussed. Limited by shares, my liability is going to be limited to the amount which I have not paid on the shares. It's a 10 rupee share, 6 rupees paid. What is my liability? 4 rupees only. Company is limited by guarantee. My liability will be to the amount of guarantee which I have given. When did I give the guarantee? When the company started. When should I pay? When the company is being wound up. Third thing, unlimited company. Liability is unlimited. When should I pay? At the time of winding up. Difference between guarantee company and unlimited company. Guarantee company, my liability is only to the extent of the guarantee amount which I have to pay tomorrow at the time of winding up. Unlimited company, there's no limit at all. Sell your house, sell your kidney, sell yourself, bring in the money. This is about section 3. Section 3A talks about members are going to be severally liable in certain cases. What cases, sir? I have clearly told you, please ensure you do not run your sleepy.
No,
No, sir. No,
Sit straight, sit straight, sit straight. Everyone, sit straight. All right. I have clearly told you, please ensure whenever you're running a business, Rajshri, ensure that minimum 2 people in a private company, 7 people in case of a public company. Crystal clear? Those of you who want to make running notes, please make. It's your wish. I just don't want you to get lost in the garb of making notes of what I'm discussing. If you want to continue making notes, please do so. I leave it to you. It's your comfort. Just ensure that you're not lost while I'm discussing something. Just ensure that you're focused. All right. So section 3 says, when I'm running a company, public company, minimum 7 persons required. Private company, 2 people required. By mistake, if this number falls below, no problem. Whoever is the existing people, they have to bring in the minimum requirement once again. 6 months I will give you. Within 6 months, if you're not able to bring in, then whoever is carrying on such business will be personally liable for all the debts and obligations of the company attracted after that 6 months. Very, very important after that 6 months. We've discussed that. We have discussed this long back. All right. This is about section 3A. Then we went on to understand section 4. Section 4 talks about MOA. MOA, there are 5 clauses. Listen to me very carefully. What are those clauses? What is the mnemonic?
no class.
No, you have to be quick. You have to be very fast. No clause. Name clause, object clause, capital clause, liability clause, association clause, situation clause. I'm sorry, not 5, but 6 clauses. Now, what is section 4 saying? Please note, whenever you're making any company, the charter documents are going to be the basic documents. Now you decide what type of format do you want to use. Where is the format available? Table 8, B, C, E, D, E, F. All right. Those are the formats. Till table E, it is going to be for MOA. All right. Now, what is the format? Format is for you to use and prepare your own memorandum of association. This is because different type of companies may require different formats. That's why I've given you 5 different formats within the Companies Act itself. Crystal clear? All right. So this is about your memorandum. Very important. This also talks about no class. What is going to be no class? We have already spoken about. Section 399 of the Act says this is a public document. I've practically shown it to you during our classes how to extract MOA of companies. All right. This is available on the MCA platform itself. Please read the documents carefully before entering into any transaction with the company. Why? Tomorrow, if anything goes wrong, you cannot say I was not aware of it. Why? It's a public document. Doctrine of constructive notice comes into picture, section 399. Crystal clear, everyone? Can I continue? All right. So this is about section 4. Then section 5, articles of association. Sit straight, everyone. I am not reading word by word that you will do. I am talking about entire section, whatever is relevant. Articles of association is a document which is talking about how, when, where, what, why. All that is captured in my articles of association. All right. My daily routine, my what to do's, my things to be covered, all that is captured in my articles of association. Favorite question which is picked up in examination from this section is entrenchment of articles of association. What do you mean by entrenchment of articles of association? No need to read. Stop reading from slide. Just listen to me. All right. Section 5 is talking about articles of association entrenchment. Depending on what type of company you are, you will have to pass a resolution. Resolution for what? For entrenching your articles. But what do you mean by articles of association being entrenched? Making the law stricter for yourself. More than what it is, I'm making it stricter for myself. With me, everyone? So if you are a public company, special resolution is sufficient. If you're a private company, unanimous resolution is required in case if you want to entrench the articles of association. Crystal clear, everyone? Understood? Able to recall whatever we have discussed some time back?
Yes.
Yes. I'm sure you might not be able to recall everything. It's okay. Relax. But something at least you should be able to recall. That is more important. Let's be fair enough. Let's be realistic in these things. All right. Now we went on to understand there are formats. Where are the formats coming? Format F, table F to J. Different type of companies, different formats. Section 6 says act to override your MOA and AOA. At the end of the day, whatever you're doing, MOA, AOA, whatever rules and regulations you're framing, ensure that it is within the Companies Act. If it is going beyond the Companies Act, I don't care. Companies Act is going to override your MOA and AOA. This is what section 6 is talking about. Section 7. Now I want to incorporate a company. The moment you want to incorporate a company, there are several steps which are involved. What is more important is, Rajshri, once your company is incorporated, you get a birth certificate. And what is that birth certificate called? Certificate of Incorporation. Along with this, you also get something called CIN, CIN, Corporate Identification Number. What is this, sir? What is the Certificate of Incorporation useful for? This is used for the purpose of proving your identity, that you exist. It's an evidence of your existence. Clear, everyone? Now, very, very important. If you've been incorporated by giving false information, false declaration, knock, knock, liability is going to be unlimited. Very important. Section 464 is waiting for you. All right. This is about your entire discussion on company being incorporated. Very critical. If the tribunal is satisfied that your company has been formed for fraudulent purpose, it can pass any of these orders. One of you read quick.
If tribunal is satisfied that the company is fraudulently formed, pass such orders as it may think fit for regulation of the management of the company, including changes, if any, in its memorandum and articles in public interest or in the interest of the company and its members and creditors, or direct that liability of the members shall be unlimited, or direct removal of the name of the company from the registrar of companies, or pass an order for the winding up of the company, or pass such other orders as it may deem fit.
Clear, everyone? This is what a tribunal can do if it finds that your company has been incorporated fraudulently. Section 8 is the next topic, which talks about what kind of company are you going to be incorporated. All right. Section 8 says whenever there is a company which is started for a charitable organization, which is started for a charitable purposes, such organizations are called Section 8 companies. Everyone with me? All right. So what are Section 8 companies? Those companies which are incorporated for charitable purposes. Now you have to pay attention and listen to me very carefully. In this case, a company need not use the word limited or private limited. They are exempted from it. Second, whatever business you're doing should be for the charitable purpose. Can I make profit? Incidentally, you might have made profit. You can't stop that. But whatever profits you made should be reused for the charitable purposes itself. Can I declare dividend out of it? Don't even think about it. No, sir, I've thought about it. I've given dividend as well. Congratulations, you've done a blunder. If you've given dividend out of that profit, you are no more a Section 8 company. And very critical, Supragna, the moment you are no more a Section 8 company, you will have to operate just like other companies. Crystal clear with the concept? Everyone understood the point? All right. So this is about your Section 8 company. Next point. Is the screen visible to everyone?
Yes, sir.
Yes, sir.
Yes, no, right? Next, after Section 8 company, it comes to Section 9. Section 9 is talking about once you are a company which you're registered, you are effective as a registered company. Now, what will happen if I'm a registered company, sir? You will enjoy all those benefits which other registered companies would have enjoyed. What do you mean by that? Separate legal existence. You can go ahead and do anything that another company or another person would have done. Very, very important. You can sue and be sued. You can buy property, you can sell property, you can engage yourself in any sort of activities as long as you're a company. Company and the person who started the company are not one and the same. They're different people. Separate legal existence as a concept comes into picture the moment you are registered. Section 10 talks about effect of MOA and AOA. This MOA and AOA, the moment you are a shareholder, let's take an example. Suppose I'm a shareholder of Infosys. I was not the subscriber, but I'm a shareholder of Infosys. Law is very clear. You should have read the MOA and AOA. Once you have read the MOA and AOA, you are bound by it. Whatever is given in the MOA and AOA, that is applicable to all the members. Are you understanding? Sir, but I never signed it up. I never signed the MOA and AOA. I don't care. The moment you have subscribed to the shares of the company, you became a member, MOA is applicable on all the members. Clear, everyone? Understood the point? All right. So it is as good as they've entered into a contract without signing it. As simple as that. Section 10A says, congratulations, now you've got the business registration, you've become a company. But can I start the business immediately? Law says control. Section 10A says, before you commence, there are two important things which have to be satisfied. All right. There are two declarations which have to be given. Insist you to keep your cameras on. Listen to me very carefully. Section 10A is talking about once you're a company, all right, you cannot immediately commence your business until and unless a declaration is given by the directors within 180 days. What declaration will they give? Declaration is that your office has been registered, verified, first thing. Second thing, whoever are the subscribers to the memorandum, they have paid that amount. Very clear? All right. Whoever are the subscribers to the MOA, they have paid that amount and your registered office is verified. Why registration of office is important? Have we learned some example? Had we taken some example? Anyone?
Kolkata.
Brilliant, brilliant. All right. One office,
Paper
one
cup.
building, 3,000 companies were registered. Do you remember? We had discussed this somewhere.
Yes,
Guys,
sir.
you have to remember examples. These are not out of blue that I've given. These are all factual examples that are given. Do you remember all these topics? At least?
Yes,
All right.
sir. Yes.
This is about your company being verified. All right. Section 11 has been omitted. Section 12 talks about your registered office of the company. Very simple. Once a company is started, it should have a registered office. Open your eyes and ears. Listen to me very carefully. Within 30 days of your incorporation, you must have your registered office. This has to be verified as well, which we have already discussed on top. Verification of registered office is important. Apart from that, you have to go ahead, give the details of whatever your registered office address is. All right. Whenever you want to go ahead and pass any changes, if you want to maintain your books of account or alter anything on your MOA and AOA, that is coming under section 13. Let's quickly think about it. I want to alter my name clause. Special resolution required. Clear, everyone? All right. I have converted my public company to private company to public company. Is a separate special resolution required after conversion? Answer is no. I repeat, what are we talking about? Section 13, alteration of MOA. Sit straight, everyone. No class. I want to alter my name clause. Can I alter? Answer is yes. Whenever you want to alter, all right. Say, Ramya wants to alter it to Anjana. Now, in this case, you are altering the name of the company. Listen to me very carefully. You're completely altering the name. Special resolution required. Whenever there is a special resolution, which form comes into
MGT
picture?
14.
Has to be there at the tip of your tongue. Quick, huh? Now, second thing. If I am converting a public company into private company or private company into public company, should I pass a special resolution only for name change? Answer is no. You're already passing other resolution which will take care of this. You don't have to separately pass one resolution for dropping the word private or including the word private. Why? You're converting a public company to private. Then I have to add the word private. Is there a change in the name? Answer is yes. But should I pass a special resolution only for this? Answer is no. You're passing other resolution which will take care of this as well. Are you understanding? Second, I want to alter my object clause. Clause is very simple. Whenever you want to alter your object clause, again pass a special resolution, only then you can go ahead and alter your object clause. Very, very critical. If you have raised money, listen to me very carefully. Yeah? If you've raised money by issuing prospectus and after that you're altering the object for which you had raised the money, it is not acceptable until and unless your members are giving that approval. Do you remember? And those members who are not agreeing, you have to give them an exit offer, which are called dissenting shareholders. Okay, everyone? All right. Next thing, I want to alter the capital clause. Alter it, ensure that your alteration is accommodated by a special resolution. I want to alter the liability clause. Very simple. Ensure that you're altering it with your special resolution. I want to alter the state clause or situation clause. Depends on what you're altering. Are you altering within the city? Don't break your head. Board resolution is sufficient. Are you altering from one city to another city? Ensure that board resolution, very critical. RD, your registrar has to be informed. Are you altering from one state to another state? Special resolution required. Fourth one, if I'm altering from one ROC, all right, to another ROC, then I'm changing the registered office itself. I'm changing my daddy itself. In this case, again, you have to pass a resolution for this purpose. Do you remember? We've discussed these 4 scenarios. The next thing is, I want to alter my association or subscription clause. All right. If you want to alter your association or subscription clause, pass a special resolution. Crystal clear with the topic, everyone?
There.
Can't be altered.
Gumpal Govinda. All right. What can I alter my association or subscription clause?
No, it can't.
Don't
No.
even think about it. Don't even think about it. It's as good as asking me this question every time. Who's the first person who landed on moon? Can that change? Answer is no. Guys, I've given certain examples which you cannot afford forgetting. There's a reason behind each of these examples. I hope you recall the topics. All right. Association clause cannot be altered. This is about your alteration of MOA. Clear? Can I continue? Alteration of articles of association. Whenever you want to alter articles of association, similar topic, a special resolution has to be passed, and ensure that whatever special resolution is passed, you're informing your registrar of company by filing a form called MGT 14. Clear? Can I continue? This is
sir.
about your alterations. Section 15 talks about alteration of MOA or AOA to be noted in every copy. Whenever you're altering your MOA and AOA, you have to inform what exactly is the change, and that has to be circulated with a copy. Section 16 talks about rectification of name of a company. Very, very simple. Listen to me very clearly. Your name should not resemble any other company. Your name should not be resembling any other registered trademark as well. No, sir, my name is already similar to another company's name. Central government can go ahead and voluntarily issue a notice to you to change your name. This is the first option. Second option, your name is similar to that of another registered trademark of a proprietor. Example, I am running a company called as Maggie Limited. Possible? Answer is no, because Maggie is a registered trademark of Nestle. Tomorrow, if Nestle wants, it can go ahead, make an application to central government asking you to change your name, rectify your name. But very important, can Nestle after 100 years wake up and tell that now you have to change your name? Answer is no. How much time? How many years does it have? It has only 3 years. All right.
Yes.
Within 3 years, it has to make an application if it wants the central government to direct you to change your name. Clear, everyone? Able to recall the topics? Yes. So this is about your rectification of name. Section 17, copies of the memorandum articles to be given to every member. If any of the members are requesting for a copy of the MOA and AOA, you have to give it. Sir, sorry, sir, I forgot. No problem. There is a penalty of 1,000 rupees per day. 1,000 rupees per day. All right. Section 18 is talking about conversion of companies already registered. Now, what is this? Section 18 is saying, I want to convert a company. Which company? Public company to private, private to public. I want to go ahead and convert an OPC to public or OPC to private. I want to go ahead and convert an OPC to Section 8 company.
Section 8, no.
Don't say a yes in the flow for everything. Those of you who said no, great. Those of you who said yes, open your eyes and ears. You're not in the session. That's a problem. Let's take it one by one. I want to convert a public company to a private company. Aditya, can I do so? Answer is 100% yes. Sit straight, sit straight, sit straight. Those of you who are losing out on your energy, keep scribbling something. Good. You scribble. You scribble anything that you want. All right. In case if I want to convert a public company to a private company, law says first thing that you have to do is ensure that your total number of members are within 200. Do you remember? We have discussed this. Second, your name has to be changed. You have to add the word private. Your MOA, AOA will change because accordingly you will have to incorporate those points. Clear, everyone? Public to private, simpler. Private to public. Now again, minimum number of members have to increase from 2 to 7. You have to remove the word private from your name and you will have to pass a special resolution and a couple of simple things which have been listed out. No problem. Trisha? Third thing, I want to convert an OPC to a public company or OPC to a private company. Accordingly, make those changes. All right. OPC to a public company possible? Yes. OPC to private company possible? Yes. OPC to Section 8 company possible? Don't even think about it. Section 8 and OPC are two distinct, they are broken up lovers. All right. Now they can't go ahead along with each other. Simple as that. Are you clear, everyone? Might sound stupid, but this is exactly what I could think of right now. I want you to remember the concepts at any cost. Simple as that. All right. So this is about your conversion of company. Now, very important that you will have to remember, inform your daddy. Daddy will issue a new birth certificate, which is going to be a new certificate of incorporation. Very critical. All right. Such conversion will not change your debts, liabilities, penalties, whatever ongoing proceedings are there. That will continue as is. That will not change. Clear, everyone? Then Section 19, me ordering what my dad should do in life. Wow. Subsidiary cannot hold shares in holding company. Clear? Subsidiaries cannot hold shares in the holding company. Are there exceptions? Only 3 exceptions which we have seen. First one, representative. Second one, trustee. Third one, I was holding the shares even before becoming a subsidiary. In these 3 exception cases, subsidiary can continue holding the shares or else subsidiary cannot hold the shares of the holding company. Even though you fall under these 3, still voting right will not be available. You are falling under the exception, still voting right is not available. Clear? Can I continue? All right. There in the session
Yes,
or
sir.
lost?
Yes, sir.
Yes, sir.
Let's go ahead. Next. This is about Section 19. Section 20, very, very important. Make a note of this important topic. Right. Open your books. Quick. Service by post. Topic which is going to be there in Section 20 of Companies Act. And General Clauses Act, Nitya. General Clauses Act. We had come across this topic somewhere we had discussed. All right.
7.
Please note. Please note. Very, very important topic from examination perspective. Either of this can be asked in examination. Either of this can be asked in examination. Am I making sense? Everyone with me? All right. Time and again, they have asked the question from this. Now, what is this? This section is just saying, sir, how to send notices, how to send documents whenever you're sending it. This is what Section 20 is all about. Nothing I funda. 21 talks about who is going to sign the documents. The documents, whichever we talk about, whatever proceedings are there, all the contracts will be signed by the directors, the KMP, or any other officer who has been authorized by the board of directors. 22, whichever bill of exchange, whatever checks are there, who's going to sign it? Whenever there are these instruments which are signed in the name of company, it has to be authorized person only. Nobody else can go ahead and sign it. Simple, nothing hyphen die here. I think the rest are simple pointers. Can one of you quickly read for government companies and all?
For government companies, suffix private limited is not required. Central government to delegate the power to ROC to register Section 8 companies. Wide notification and exercise of powers conferred by Section 458 of the Companies Act. The central government to delegate the power to issue licenses to Section 8 company to regional directors. Earlier, the word national cannot be used unless it is a government company. However, now it is allowed. The name bank cannot be used unless it is a bank. The name of the company shall be in complied with emblems and names, prevention of improper use of Act 1950.
All right. There are two things. One, it should be in compliance with emblems and names, and prevention of improper use of names. All right. Act 1950. Clear, everyone? Can I continue? We are done with the second
Yes.
chapter as well. Now going ahead with the third chapter, prospectus and allotment of securities, our favorite topic. All right. Prospectus, section 2 clause 70 defines prospectus. Prospectus means any document which is described or issued as prospectus. This also includes red herring prospectus, shelf prospectus, deemed prospectus. Although they have not used the word deemed prospectus, but any notice, circular, advertisement which is inviting offers from public for subscription of shares or any of the securities of the company will be considered as a prospectus. Indirectly, they've used the word deemed prospectus. Section 23 is talking about public offer and private placement. How do I beg, borrow, steal? Section 23 says, if you're a public company, you can beg by private placements, public offers, IPOs, or nothing but your right issues and bonus issues. Private company, in case if you want to go ahead and beg, borrow, right issues, bonus issues, and private placement. Public offer?
No, sir.
No,
No,
sir.
sir.
Prohibition. Section 2 clause 68, prohibition. All right, private companies are prohibited. That is the reason for the no that we are talking about. Clear, everyone? Can I continue? Now, section 25 talks about document containing an offer of securities for sale to be a deemed prospectus. This is an important section. Section 25 is talking about deemed prospectus. Example, seeing so much of Bhelpuri around the topic prospectus, so many liabilities, I don't want to take the chance. What am I doing? I am taking a bundle of my shares, giving it to you. Now you are unloading, offloading it in the market. For this, you are issuing some document. Law says whatever document you will issue will be considered as my prospectus, deemed to be my prospectus. Why? Because what you're doing is OFS. What is OFS? Offer for sale. Clear? We have discussed this earlier as well. Now, please note there are three types of public offers: fresh issue, further issue, which is nothing but IPO, FPO, and the third one is an OFS, where existing shareholders are offloading their shares in the market. But the moment they do it, the quantity, markets will crash. Higher the supply, lower the demand, markets will crash. So what am I doing? I am doing it in the form of a public offer. Here, everyone understanding the topic? All right. Now, law says use your own prospectus. You are very smart. You're using somebody else's document. Law says whatever document you are issuing will be considered as my prospectus. Clear? Read one of you, section 25. Quick.
Any document by which the offer for sale to the public is made shall, for all purposes, be deemed to be a prospectus. As per section 25, subsection 1, where a company allots or agrees to allot any securities of the company with a view to all or any of those securities being offered for sale to the public, any document by which the offer for sale to the public is made shall, for all the purposes, be deemed to be a prospectus issued by the company. And all enactments and rules of law as to the contents of prospectus and as to liability in respect of misstatements in and omissions from prospectus or otherwise relating to prospectus shall apply with the modifications specified in subsections 3 and 4 and shall have effect accordingly as if the securities had been offered to the public for subscription and as if persons accepting the offer in respect of any securities were subscribers for those securities, but without prejudice to the liability, if any, of the persons by whom the offer is made in respect of misstatements contained in the document or otherwise in respect thereof. Regards document for offer of sale of securities as a deemed prospectus unless contrary proved, if an offer of securities or of any of them for sale to the public was made within 6 months after the allotment or agreement to allot or at the date when the offer was made, the whole consideration to be received by the company in respect of securities had not been received by it.
Simple. Two conditions. How will I know that, sir, I have given the shares to you? You have offloaded in the market. How will I blame that whatever document you've used is to be considered as mine? Law says check for these two conditions. Usually, when I'm giving shares to you, you would want to hold. You've offloaded within 6 months. First, red light. Second, I didn't collect the money from you. Why would somebody not collect the money? Think logically. Are you with me, everyone? All right. Let's take an example. Infosys Limited, all right, has a bundle of its shares. Directly, if it goes to the market, it knows there are 1,000 problems. I don't want to take this problem. I don't want to take this chance. So what am I doing? I will catch you. I am giving this entire bundle to you. You go offload it in the market, do whatever you want to do. You put it on Instagram, you put it on Facebook, you put it on your face. I don't care. Get this property sold. Get this security sold. Law says check for two conditions. This document will end up becoming my prospectus. Check for two conditions. What two conditions? First, did you offload it in the market within 6 months? Usually people don't do. If you have done it, no problem. Sir, it might be a genuine transaction, so I'll not doubt that. Second case, did I receive my entire consideration when I gave it to you, or did I receive it later on? If I've received it later on, then 100% something is dirty in it. Are you understanding? All right. Something is 100% missing in this. That's exactly why I'm calling it as a deemed prospectus. Whatever document you issue for the purpose of publicizing this entire issue will be considered as my deemed prospectus, will be considered as my prospectus. Clear with the concept, everyone? Understood the concept? Yes. Important topic, section 25. Section 26 talks about what all data should be reflecting in the prospectus. Prospectus has to be dated, signed. It has to contain all the relevant information which we have discussed. There are three types of information: general information, financial information, which is the third one. Quick. Which is the third one?
Strategy.
GFS. All right. We've discussed this in length. General information, financial information, statutory information. We have captured all of these during our regular classes, if you remember. Now check if all the three are covered here or not. Next thing, prospectus should to be including all those reports which are required. Prospectus cannot be issued to public until a copy has been delivered to the registrar. Prospectus shall include a statement by the expert opinion. Do you remember? We have discussed this as well. All right. An expert has to give an opinion. Prospectus once issued, within 90 days, it has to be delivered to the registrar as well. What will happen once a prospectus has been issued? You have to ensure that whatever amount is received, for what purpose am I going to use it? Time and place, if somebody wants to come and review the contract, and within what number of days am I going to allot the shares? All of this has to be captured in your prospectus. Section 27, very interesting, is talking about I've raised the money, but now I want to alter the vary the terms. Are you with me? Listen to me very carefully. I've raised the money, but now I want to vary the terms for which I've raised the money. I've raised it for EV segment, but suddenly I realized that nobody is using EV anymore. Or rather, I've raised the money for petrol vehicles, but suddenly I realized that nobody is using petrol vehicles anymore. Everybody's going towards EV. That means I'm changing the objective. Now law says you've raised the money for X purposes, but you are varying your terms in contract. Law says you cannot do so until and unless special resolution is passed. Second thing, details of such resolution has to be published in the newspaper. Clear, everyone? Dissenting shareholders have to be given an exit option, and this is nothing but the same topic which we discussed some time back. If you remember, object clause, if you want to alter the object clause for a situation where you've raised money, it can be done only with a special resolution. Clear, everyone? Can I continue?
Yes.
Yes, sir.
Little
Yes,
energy.
sir.
Yes, sir.
Yes, sir.
Sir.
Go
Yes, sir.
ahead. Section 28 is talking about offer of sale of shares by certain members of the company. Whenever any members want to go ahead and offload their shares, because of the bulk in the volume, they can do so through the company by a public offer. Mainly talking about section 28, which we've discussed earlier. Section 29, whenever any public offer is being made, it has to be in the dematerialized form. It cannot be in paper format. It has to be in an electronic format. That is nothing but the dematerialized form, or the demat account that we are talking about. Then section 31, 32, 33, three important sections which are talking about types of prospectus. First one, shelf prospectus. I want to make multiple offers. Once I have begged, I like begging so much that I want to beg often now. In that case, I can't go ahead and issue prospectus every now and then. It's like a bookshelf. I made one main document. Every time I go ahead with a public offer, I will go ahead and use the same document itself, same prospectus itself. But new information which I want to give every now and then will be through a document called information memorandum. Clear, everyone? This is shelf prospectus. What is the validity period of this shelf prospectus? It's going to be valid only for 1 year. Second is section 32, which talks about red herring prospectus. I want to find out from public how much are they ready to pay. All right, this is called book building process. Do you remember we've discussed what is book building? I want to understand from public how much are they ready to pay. So in that case, I will issue a prospectus which has all the information except for two things: price and number of shares. Price and number of shares. Paid up capital, total issue of the capital, all that will be there. But at what price am I going to issue? I don't know. Second, how many shares am I going to issue? I don't know, because I know the total amount I want to raise, but I don't know the price. I know the numerator. I don't know the denominator. And until and unless I know the denominator, I'll not be able to find out how many shares I'll be issuing. Clear? Eh? All right. This is called red herring prospectus. Once a red herring prospectus is also called information memorandum. I've told you, don't get confused between the information memorandum, which is used in red herring prospectus, as well as shelf prospectus. Red herring prospectus is also called information memorandum, full stop. Shelf prospectus, whenever you're making next issue within that validity period of 1 year, whenever I'm making multiple issues, I will use one single small document, which is called information memorandum. Why? Main prospectus I've already issued, which is called shelf prospectus. Clear? Everyone understood the point? This is about your shelf prospectus. Section 34 is talking about criminal liability for misstatement. Section 35 is talking about civil liability for misstatements. Very, very critical. If you've given any wrong information, all right, section 447 waiting for you. By mistake, if you've given any wrong information, section 447 is waiting for you. This is criminal liability. Civil liability, whatever people have lost, that has to be reinforced, that has to be provided once again. Section 36 is talking about fraudulently if you're inducing people to invest. Classic case. Last week, all right. I'm just not able to recall the name. It was Sathe, all right, Sathe. I'm just not able to recall the entire name. All right, I know his surname. Person was booked recently. 560 crores penalty. I repeat, individual, 560 crores penalty. Why? Fraudulently inducing people to buy the shares of a company. Example, Infosys shares are there. I am coming and telling you, this is the best shares. If you don't invest in this, your entire money is lying idle. Nothing can be done better if you can't invest it in this share. What am I doing? I'm fraudulently convincing you. I know there's nothing in that share. Example, Kingfisher Airlines. Not the Kingfisher substance. All right. I am talking about Kingfisher Airlines. Neither the king nor the fisher, both are not visible. But still, I am inducing you to buy the shares of that company. Very clear. I will be booked under section 447 because I'm fraudulently inducing you to buy the shares of the company. Crystal clear with the concept? Everyone? Yes? I'm sorry. It is Avadut Sathe. All right. AVADHUTH Very interesting. What the person has done, Google later on sometime. All right. 560 crores. Just 1 or 2 weeks back itself. Very interesting story. Don't Google now. Listen to me right now. All right. Section 36 is talking about fraudulently inducing people. Section 37, whoever those small shareholders, they will not be able to bear the cost of litigation in India. All right. So law says you can file something called as class action suits under section 37. What is a class action suit? You belong to a particular class. What class? Small shareholders who are cheated, who are duped by the company. Now, in this case, you can go ahead, make an application as a group to the law, to the court, and this will be called as a class action suit. Clear? Next thing, section 39, allotment of securities. Once I receive the money, law is very clear. Don't keep the money with yourself. Allot the securities within the limited period of time. All right. So first thing, did I get the minimum subscription or not? Classic example. Just last week, there was a company which is called IHZ or something. All right. I'm just not able to recall the entire name. IHZ had a problem of under subscription. We are in the boom of IPOs. You open a news channel, business news channel, you will find 100 IPOs being discussed. This was one of the IPOs just 1 or 2 weeks back. All right. And this company had a problem of minimum subscription. Worst case, underwriters also said we are not going to subscribe because their underwriting was only to a limited portion. So law says very simple. You have to get the minimum subscription. What is minimum subscription? 90% of your shares have to be subscribed the moment you make a public issue. Now, sir, in case if I'm not getting that public issue successfully from the public, in that case, at least have your backup. And who's the backup? It's your underwriters. Now, suppose if I don't have a backup, then your public issue is failure. You have failed in this public issue. Clear? Now, law says whenever you've got the money, This is going to be considered the application money. Application money has to be minimum 5 days. Once you receive, if you do not receive the application money within 30 days, whatever amount you have collected, please refund it. Allotment of return of allotment has to be filed by the company. Section 40. Whenever you're dealing, securities have to be dealt with in stock exchanges. You have to subscribe to the stock exchange. In your prospectus, you have to give the details of which stock exchange are you. There is certain amount which you have to maintain with the stock exchanges. All that is going to be captured here, Kirtana. Section 42. The last topic in this section, which is your private placement. Sit straight, everyone. All right. Private placement is a way wherein even a private company can go ahead and beg. Not just a public company, even a private company can go ahead and beg. Listen to me very carefully, sit straight. What is private placement? I don't want to go ahead and make my offer to 1,000 people. Might as well just find 10 Ambanis and place myself amongst them. Simple. This is private placement. I'm not going to the world. I'm privately placing myself amongst few people. For this as well, I have to issue a document called as PPO, private placement offer. Law is very clear. Whenever you're coming up with private placement, please ensure the offer is not to more than 200 people, excluding your QIBs and ESOPs. Very clear? Everyone with me? All right. The maximum number of people who can be included in one private placement is going to be 200. Listen to me very carefully. How many such private placements can I do? Is the screen visible to everyone?
Yes.
Yes. Listen to me very carefully. In each private placement, all right, I will go ahead, I will ensure that the QIBs and ESOPs are not included. And whatever private placements I do, I have to ensure that there is sufficient time gap in a year. All right, I can't do any number of private placements that I want. Clear, everyone understanding the point? All right, mark section 42 as one of the most important topics from this topic. You can get quite a lot of questions from here. Clear? We are done with the first module. Now we go ahead with straight away jumping into the liability. If one of you quickly read the liability for misstatement.
Liability for misstatement to our remarks, left side criminal liability. Every person who authorized prospectus punishable under section 447, defenses which are immaterial and reasonable ground to believe. Civil liability, company, director, proposed director, promoter, expert, one who authorized, pay compensation to investors. Defenses withdrew consent to be director, believed on consent under section 26 subsection 5, issued without his knowledge, public notice.
What is this defenses? How can he defend themselves? All right. Tomorrow, if the court are holding them responsible, can they come up with an argument to save themselves from the penalty under section 447 or any other thing? That is what is the meaning of the word defenses. Clear, everyone? Understanding the point? All right. This is about your prospectus chapter. Now let's quickly get into, is the screen visible to everyone?
Yes.
Yes, sir.
Yes.
Yes, sir.
Let's quickly take a small break from Companies Act and quickly go to, is this, yes, let's go to General Clauses
Yes.
Act. Let's get started with General Clauses Act. Is the screen visible? Yes.
Yes, sir.
Yes, sir.
All right.
Yes, sir.
So General Clauses Act, again, this act is a very old act, which is just to ensure that your reading of law becomes easier. The objective of this act is, first one, shorten the language of the central acts. Second one, as far as possible, bring in uniformity and consistency in the definitions. Third one, give rules and regulations which can be used for interpretation and construction of law. Fourth one, to safeguard any improper, inappropriate importing of meanings whenever you're reading law. In simple terms, why do I need this law, sir? I want to shorten the language. I want to ensure there is consistency. I want to give a set of rules and regulations which I can use for the purpose of reading law. Please note, General Clauses Act 1897 is applicable only to central acts. It is not applicable to the state acts. For state acts, what do we have? Their State General Clauses Act, which is available for them. Clear? Everyone understood the point? All right. So your General Clauses Act is applicable for the central acts. Now, does it have a territorial extent clause? Answer is no. This is not having any territorial extent clause. We've discussed this. Do you recall, Srisha, there? So what do you mean by territorial extent clause? To which state does it apply? It does not have any such clause. Why? Reason being very simple. It follows wherever the same example. All right. It's that pug in the Vodafone advertisement. Wherever the master goes, the pug follows, the dog follows. This is exactly what we talk about the territorial extent clause. Wherever the central act is applicable, the General Clauses Act can be referred for interpreting such central act in such territory. Crystal clear? It does not have a territorial extent clause. Very, very important topic. One of you read the territorial extent clause. Quick, anyone?
The Act does not define any territorial extent clause. Its application is primarily with reference to all central legislation and also to rules and regulations made under a central act. It is, in a sense, a part of every central act or regulation. If a central act is extended to any territory, the General Clauses Act would also deem to be applicable in that territory and would apply in the construction of that central act. It may also be noted that the Act does not in terms apply to state laws. It is evident that the State General Act should conform to General Clauses Act 1897, for otherwise divergent rules of construction and interpretation would apply. As a
Very
result,
simple.
great confusion might ensue.
Might ensure. All right. So this is about your territorial clause. Please mark this important. It's an important topic which can come in examination. Last 15 minutes I've just kept for the purpose of discussing how to go about with the subjects preparation. All right. So those of you who have plans of quitting right now, you quit. Don't come in the fag end and then tell that I was waiting for all this and not acceptable. All right. Please ensure if you're here, let's give sufficient time to each other and ensure that we are doing justice. Coming back to the next topic. All right. There are few definitions which are there in this act. I want you to know each and every definition which is there in this entire topic. I am telling you 30 marks easy to score in examination if you know 3 chapters. General Clauses Act, Interpretation and FEMA. I repeat, 3 simple topics, 30 marks in your hands. All that you have to do is then push your score from your Companies Act as much as possible. Am I clear, everyone? If you're reading Companies Act for the next May attempt, if you're reading it 4 times, General Clauses Act, Interpretation of Statute and FEMA has to be read at least 7 times. Am I clear? Everyone making sense out of what I'm saying? Everyone with me? All right. So what are the definitions, sir? Preamble. What exactly is preamble? Preamble is an introductory portion of every act which is talking about the objective of every act. Why am I laying down that act? It talks about the scope. Can I use preamble for interpretation of statute? 100% yes. Majority of the questions which are revolving in the constitution have been picked up to resolve based on the preamble. I've given you an example as well long back. All right. The whole issue on LGBTQ was resolved because of the preamble itself. Am I there? Everyone with me? Understanding the point? All right. Second thing which I want you to understand is definition of the word definition. All right. So the meaning of the word definition is to tell what do you concisely mean when any word is being used in that context. Now, there could be different types of definition. It could be an inclusive definition, which is the widest definition because of the usage of the word includes. It could be an exhaustive definition because of the usage of the word means. Sleepy?
No.
All those of you taking support of your so-called pillow there, all right, leave that and sit straight, everyone. All right. The third one, it could be a exhaustive exclusive definition where I'm using the word excludes. Fourth one, it could be an exclusive and or rather exhaustive and inclusive definition. It could be an exhaustive and inclusive definition. All the 5 variants you've seen first or second page of your income tax material where they have been defined with an example as well. Am I clear, everyone? The next topic which we came across was shall and may. What do you mean by the word shall? Shall is mandatory in force. When it comes to may is directory in force. It's not compelling anyone. It's up to you. If you want, you go ahead and follow. But there are instances where you might have to read the may as shall and shall as may. Each one of you sitting here should be able to quote an example for this. Which one?
Company may be formed.
Company may be formed.
Section 3 of the Companies Act 2013. Company may be formed. Ideally, that may is not for the purpose of purpose. That may is not used for purpose. It's for formation. But if you interpret it for the purpose, then you will not read the word may as may. You have to read the word may as shall. Clear, everyone? I am not sure of people around you, whether they are listening, they might be thinking this is out of blue, something is being spoken, but you should be able to understand what I'm talking about. All right, may being read as shall and shall as may and all that. All right, can I continue? Everyone with me?
Yes, sir.
The next thing is section 3. The definitions under General Clauses Act are covered under 3 important sections: section 3, section 3 and 4. Listen to me very carefully. Section 3 is giving a list of all those definitions which are applicable to all the acts which are effective. All right. Very, very important. This definition, whichever is listed in section 3, Bhavani, is applicable even to the General Clauses Act of 1881 and General Clauses Act of 1880 and all those acts which are passed after 1897. What are we talking about? Sir, General Clauses Act came into picture in 1897. Was there any other General Clauses Act? Answer is yes. 1881 was another General Clauses Act. So the law is very simple. Whatever definitions you're learning in 1897, that applies to your previous General Clauses Act as well. Clear? I cannot go change that act. It's as good as, guys, can I make amendments in 1956 Act now? Companies Act 1956. What nonsense. That act has been repealed. Now we are talking about 2013. So what am I doing? I am going ahead making changes in 2013 itself by saying that whatever definitions you're going to learn in 2013 is applicable even to 1956. This is similar to what they have done in General Clauses Act. Whatever definitions you see in section 3, all right, those definitions you assume they existed under 1881 as well. Why is it important? Lot of acts have been passed in the intermittent from 1881 to 1897. Classic examples are listed. Negotiable Instruments Act, it could be multiple acts which have been listed there. Are you with me, everyone? All right. So what are the definitions? There are a few definitions such as affidavit, Central Act, government securities. I want you to know affidavit definition. All right. What is the meaning of the word affidavit? It's an oath in writing. It's an affirmation in writing. And this is swearing in front. You're taking this oath in front of somebody. And that somebody is a lawyer. Sleepy?
No, sir.
No, sir.
Second, there is something called good faith, which you will come across. Please note, there have been several instances where they have asked about good faith. Now, you guys are sitting here, honestly. Are you doing something in good faith? Ideally, yes. But your mind is wandering about what mom would have cooked. What is my plan after 8 o'clock? Is this in good faith? Then you're sitting? There are two views. There are two views to this. All right. First view, are you sitting here? That in itself is good faith. Second view, if you're sitting here, but your mind is wandering somewhere else, that means merely being honest is of no use. Negligence is of no use in your good faith definition. You will be diligent, not negligent. Only honesty does not work. Diligence is equally important when you're talking about good faith. This is coming from a case law of Mong Si Mong and Mong Si Poo. Everyone with me? All right, Mong Ong Poo versus Mong Si Mong. Everyone with me?
Yes, sir.
Understanding? Yes.
Yes, sir.
So in this case, they've gone ahead to interpret the word good faith and saying that merely honesty is not sufficient if you're not being diligent. That means I'm honest, sir. I'm sitting here. What else do you want? My camera is also on. But my mind is thinking about the food. My mind is thinking about tomorrow what I got to wear. This is not good faith as per Mong Ong Poo. All right. Very clear. Everyone with me? However, the first definition says anything done honestly is going to be considered as good faith. One of you quickly read section definition of the word good faith. Very important topic. Huh?
Good faith, section
Good
3.
faith.
Section
Good
3.
faith,
clause-
section 3.
Just a
Good
second.
faith,
Just a
section
second.
3, clause section 3, subsection 22. A thing shall be deemed to be done in good faith, where it is in fact done honestly, whether it is done negligently or not. The question of good faith under the question of good faith, question
The
of good
question
faith
of
under
good
the
faith
General
under the
Clauses
question of
Act is one fact. It is to determine with reference to the circumstances of each case. The term good faith has been defined differently in different enactments. This definition of the good faith does not apply to that enactment which contains a special definition of the term good faith, and there the definition given in that particular enactment has to be followed.
Did you
There-
understand? If my act, if the specific central act is already given a definition of good faith, you follow what is there. You don't come here. If there is no definition in your central act, only then you come to General Clauses Act. That's exactly what we do, right? If there is a definition of the word assessee, will I come to General Clauses Act and see what is the definition of the word assessee here? Does
No,
not make
sir.
sense.
No, sir.
Everyone got the point? Read next.
This definition may be applied only if there is nothing repugnant in the subject or context, and if that is so, the definition is not applicable. In Mong Ong Po versus Mong Si Mong, it was pointed out
sorry.
that the expression good faith is not defined in the Indian Contract Act 1872, and the definition given here in the General Clauses Act 1897 does not expressly apply the term on the Indian Contract Act. The definition of good faith, as is generally understood in the civil law, and which may take as a practical guide in understanding the expression in the Contract Act, is that nothing is said to be done in good faith which is done without due care and
negligence. All right.
due care and attention as is expected with a man of ordinary prudence. An honest purchase made carelessly without making proper inquiries cannot be said to have been made in good faith so as to convey good title.
Crystal clear with the concept, everyone got the point of what we are talking about. Good faith. Can I continue? All right. Apart from this, there are definitions. Yes, there we are talking about a couple of other definitions like official gazette. We are talking about application of the foregoing sections. All right. Whatever definitions we have spoken about, is it applicable to the previous enactment? Answer is yes. Whatever definitions we have spoken about applies even to the previous enactment, which covers your General Clauses Act of 1868 and General Clauses Act of 1887 as well. Application of few certain definitions which comes into picture here. We had spoken about Consolidated Fund of India. All right. If you remember, we had taken this understanding of what do you mean by the Consolidated Fund of India. Every time any money which is being spent by the central government, it is going out of the Consolidated Fund of India. Now, this is the general pool of the government. Please note, if I have to spend even 1 rupee from here, Parliament approval is required. Sir, where are they taking approval? The whole finance budget, which is being discussed on every February 1st, is nothing but this discussion itself on consolidated fund. How should we use it? Are you able to understand? Everyone with me? All right. So that is the whole discussion revolving around Consolidated Fund of India. Can I continue?
Yes, sir.
Everyone?
Yes,
All right.
yes, yes.
General rules of construction coming into operation. When does an act come into operation? It is going to be effective. If the date has been given, then it is effective from that date. Darshan there? All right, Sharon. In case if date has not been mentioned, then what will I do? The moment precedent assent has been given, it is going to be effective from there. Clear, Smita? Can I continue? So this is about your coming into effect. Rajni, effect of repeal, section 6. Please note, there have been few attempts where they have not spoken about repeal. I will not be surprised if this time now they start picking repeal. Why? Income Tax Act 1961 has got repealed and 2025 has come in. So they have all good thoughts to bring in the questions on repeal. There is 100% purpose as well right now to talk about repeal. Please note, questions will be framed first priority from practical requirements as well. Now is the requirement. I hope everybody is aware, right? Income Tax Act 1961 is going to be repealed very soon.
Sir.
Income
Yes,
Tax
yes,
Act 2025
yes,
is brought in. Now, interesting is what will happen on 1st February. I don't know. All right. It's going to be a big question mark whether they are going to update the old one or whether they are going to come up with something new in the new one. I have no idea. All right. I'm not sure how many of you understood. Those of you didn't, it's okay. Coming back to the point, the effect of repeal. What is the meaning of the word repeal? I am closing the old act, not applicable anymore. All right. Classic example, Income Tax Act 1961. It's going to be repealed. Another example, Companies Act 1956. That's been repealed. That's why Companies Act 2013 came into picture. The new law has come into picture. What happened to the old one? That has been repealed. Now the question is, the moment it is repealed, what will happen? All those karmas which you've done under the old act, that means you don't have to pay for it. Whatever decisions you've taken under the old act, that means that is not relevant. Whatever penalties, whatever fines, whatever responsibilities, liabilities which were there under the old act, that is not relevant anymore. Law says, wait, just because I've repealed, whatever you've done, that will not be affected. That will continue as it is. Let's suppose some proceedings have been initiated against me under the old act. Will that stop? Answer is no. That will continue. Let's suppose there is some decision which I've taken under the old act. Will that come to an end? Answer is no. That will continue. Whatever has been done under the old act, that cannot be brought to a stop by the new act. Clear, everyone? Understood the point? Read, one of you. Quick, effect of repeal.
Effect of repeal, section 6, where any central legislation or any regulation made after the commencement of this act repeals any act made or yet to be made, unless other purpose exists. The repeal shall not revive anything not enforced or prevailed during the period at which
Chitralika,
repeal
hold. Shall not. Open your eyes, ears, and listen to me very carefully. That repeal shall not revive anything which was not enforced, affect anything which was already discussed. Go ahead. Shall not. I want you to read the word shall not first and then continue with the pointers.
Yes, sir. The repeal shall not revive anything not enforced or prevailed during the period at which repeal is effected, or shall not affect the prior management of any legislation that is repealed or anything performed or undergone, or shall not affect any claim, privilege, responsibility, or debt obtained, unused, or sustained under any legislation so repealed, or shall not affect any punishment, forfeiture, or penalty sustained with regard to any offence committed as opposed to any legislation, or shall not affect any inquiry, litigation, or remedy with regard to such claim, privilege, or a debt or responsibility, or any inquiry, litigation, or remedy may be initiated, continued, or insisted.
Write this as one of the most important topics from your examination perspective. I'll not be surprised if this comes in examination now. All right. There's a whole reason why they can come up with this topic as well. Your entire CF fraternity is still in shock, thinking about how to use this law now, because General Clauses Act is what all of us are talking about. I am giving you a practical reality. From 1st April 2026, the moment company Income Tax Act 2026 is effective, 2025 is effective, we all don't know what to do. What we have already done, whether that will continue or not, who's going to answer? General Clauses Act, section 6, what you're learning will be the topic of discussion amongst all chartered accountants. Making sense? Everyone with me? All right. So this is effect of repeal. The next topic which you have to understand, revival of the repealed enactment. What are we talking about? Something which has been repealed. Now we want to bring it back once again. Example, Income Tax Act. For whatever good or bad reason, the government has changed. Some new government has come into picture. They are saying we don't like 2025 Income Tax Act. We want the 1961 itself. That was repealed. Now they want to revive it again. They want to bring it into force once again. Law says you cannot revive until and unless you give the objective and intention of why do you want to revive. Clear, everyone? You cannot revive until and unless you give a reason, purpose. Why do you want to revive a repealed enactment? That has to be given. Construction of references. Whenever I'm referring to Companies Act 1956, classic example, Income Tax Act 1961 is still giving references to Companies Act 1956. Now what should I do? Find the corresponding law under 2013 and that has to be read accordingly. Simple as that. Understood? Next, commencement and termination of time. Whenever you're using the word from against any date, that will not be included. Whenever you're using the word to against any date, that has to be included in the purpose of, for the purpose of your calculation of time. Computation of, rather measurement of distance. Distance, whenever we talk about, it should be on a horizontal plane. All right. When I say horizontal plane, it is to ensure that it can be measured on a horizontal plane. This is exactly what you have learned in your agricultural income. 2 kilometers, 6 kilometers, 8 kilometers, and all of that. Agricultural income. Yes. You might have come across that whole
Yes,
parota
sir.
and all of that, which you might have
Yes,
come across.
sir.
That's exactly what I'm talking about. How do you measure this 2 kilometers, 6 kilometers, 8 kilometers? You have learned there aerially. But who is saying aerially? Section here. All right. Computation of distance is going to be on a straight line, in a straight line on a horizontal plane. Gender, masculine includes feminine and singular includes plural. Construction of orders and all those which are issued under enactment. Whenever you're reading any law, notification, circular, scheme, rules, the underlying meaning of that, if you're confused, go to the respective meaning in the central act itself. Whichever act has given the meaning, go to that meaning itself. When I give you the power to issue, I also give you the power to rescind, amend, vary. What is the meaning of this? If I give you the power to go ahead and issue a law, you also have the power to delete it, to change it, to amend it. All right. Last one is section 24, which is talking about continuation of orders under enactment repealed and reenacted. What is the meaning of this? Whatever orders were passed under the repealed enactment, and that act has been reenacted or revived, those orders which were passed under the repealed enactment will still continue applicable. Because why? The underlying act has also been reenacted. So go ahead and use those orders also for reference purposes. This is about your section 24, meaning of service by post. Just some time back, I have told you section 20 under Companies Act is important. Section 27 under General Clauses Act is important. Meaning by service of post. What do you mean by service of post? Whenever you're sending any documents, ensure that it is properly addressed, prepaid, sent by registered post. 3 important parameters. Only then it will be a valid document. Last topic, section 26. Can you be punished twice for the same blunder? Do you remember we had discussed this as well? We had taken an example. All right. So can I be punished for the same mistake twice? Law says no. A trial can be conducted under all the laws, but punishment will be only under one. Do you remember what is the meaning of the word trial? Can I check under all the laws what all karma have you done? Answer is yes. But punishment will be only under one. And that is exactly what section 26 is all about. Clear? Next topic is interpretation of statute. Sit straight. Probably the last topic which I want to discuss in today's session. Not sure how many of you realize 4 chapters done in 1 hour, 20 odd minutes. I am revising. I'm going fast. I'm sure not everything would have been covered, but the whole objective is to get you back to the topics. That's the whole objective. Interpretation of statute. Again, one of the most important topics, guys. I've told you this time and again. These 3 chapters have to be at the tip of my tongue. January, first week, you will have a test once again on both these topics. I repeat, January first week, once we are back, all right, or whatever holiday is and blah, 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 we celebrate the new year with these 2 topics. I'm loud and clear. Come prepared as if it's going to be the toughest paper that you come across. 2 topics I'm announcing today. What is the date today? Today is 21st, right?
Yes.
21st. January 1st week. You have sufficient time. Almost effectively, I'm giving you 10 to 12 days. 2 chapters is what I'm asking. Ensure that you know head and tail of each and every word which is covered there. Be prepared for one of the toughest tests which you will come across till date on these 2 topics. So come prepared. Read everything under the sky that you can, RTPs, MTPs, whatever it is, read and come. You will be tested on these 2 topics. All right. Going back to the interpretation of statute. What do you mean by this? 3 important words. First one, what do you mean by the word statute? Statute is an intention of law. What is exactly law wants you to do? That is given in the statute. You come across 3 important words: DID, document, information, deed. Everyone with me? All right. Document, instrument, and deed. Document is any piece of paper, is any evidence which is giving you certain information. What is instrument? Instrument is a document which is in writing, which is formally notarized. What is a deed? Deed is an instrument in writing which has been stamped under the act and acknowledged by parties entering into it. Again, next topic is interpretation. What do you mean by the word interpretation? Finding out the real meaning of the words which have been used in the law. That is what is called as the meaning of the word interpretation. To find out the intent of the law, to find out the intent of the lawmakers. Just allow me a second. All right. To find out the meaning of the real intent of the lawmakers is what is called as the interpretation of statute. You have to go ahead and then read what are the rules of interpretation. We've spent good time. Sit straight. I'm quickly going to revise this now. Interpretation of statute under 2 buckets: primary rules, secondary rules. Primary rules, 6 important rules that we come across. Literal construction, literally interpreting the law as is, also called litera legis. All right. Understanding the word by word, understanding the law word by word, giving an effect to each and every word which has been used by the lawmakers. Second one is rule of reasonable construction. When you're reading the law, if there are 2 alternative views, all right, 2 views which are coming into picture, one making the law useless and or not worthy of any interpretation, the other one giving a meaningful interpretation, use the one which is more reasonable, which is meaningful. Third one, rule of harmonious construction. Whenever you're reading law, ensure that you read all the corresponding topics on the law. However, if there is a conflict between the laws, ensure that as far as possible, you can harmonize, read them together, giving an effect to all the laws. However, where it is not possible at all to harmonize, specific overrides general, latter provisions override former. This is your rule of harmonious construction. Clear, everyone? Rule of beneficial construction, also called Hayden's rule, also called mischief rule. All right. Rule of beneficial construction means when you're reading the law, you have to read the law in such a way that you can suppress the mischief and advance the remedy. Language, everyone. Suppress the mischief and advance the remedy. This is called rule of beneficial construction. Rule of exceptional construction, when you're reading law, usually each and every word has a meaning attached to it. And or, when you're reading and or, and means all the conditions to be satisfied, or means any of the conditions to be satisfied. Shall, may. Shall is mandatory in nature, may is directory in nature. However, if there are instances where giving meaning to these words will make the law inappropriate, then you will interpret it vice versa. And has to be read as or has to be read as and. Shall has to be read as may has to be read as shall. Clear, everyone? Understanding? The last one is called rule of agestum generis. Whenever there are series of specific words followed by a general word, the general word will derive its meaning from the associated specific words. Lion, tiger, etc. The word etc. derives its meaning from lion and tiger. That means we are talking about wild animals. Can cow, buffalo, hen, anything come in this? Answer is no. Why? Because we are talking about wild animals. Clear, everyone? Understood the point? All right, this is rule of agestum generis. Guys, 6 important rules should be there at the tip of your tongue. Secondary rules. Secondary rules, you will come across something called effect of usage whenever you're using the words, how it has to be used, and associated words to be understood in a common word. This is nothing but your common nocitor a sources. All right. Nocitor a sources is similar to agestum generis, but not the same. Because in agestum generis, we use common words like etc., others. In nocitor a sources, we don't use etc. and all. We are using specific words. But those specific words also can have multiple meanings. So you see what is the associated words with which they are placed. Example, toiletry, comma, perfumes, comma, etc. Whatever the word is. Now the word perfumery cannot include industrial perfumes. Do you remember the example?
Yes, sir.
Yes, sir.
We discussed this. Do you recall? All right.
Yes,
This
sir.
is about your nocitor a sources. Next. Primary rules of construction, we've already discussed what are rules of harmonious construction and all of this we have discussed. Please spend some time on understanding each of these words. Very, very critical. All right. I think secondary one left is expressio unius est exclusio alterius. What is the meaning of this? Expressly mentioning one thing will automatically remove all the alternatives. Example, which example had we taken? Anyone? Gold mines, coal mines. Somewhere, some mines we had discussed. Do you remember? Land, comma, buildings, comma, coal mine. Now, does this include iron mines? Does it include gold mines? Answer is no, because they have categorically used the word coal mines. Everyone with me? Read expressio unius ex exclusio. Read, one of you, quick.
The maxim means that express mention of one thing implies the exclusion of another. As per this maxim, if 2 or more things belonging to a particular class are mentioned, other members of that class are silently excluded.
Clear, everyone? Understood? All right. This is about your expressio unius est exclusio alterius. Crystal clear. The next one was nocitor a sources, and the last one is contemporaneo expositio. What is the meaning of the word contemporaneo expositio? When you're reading the law, please try to interpret the law based on the time frame when it was made. That makes the law even clear. All right. Classic example, when today's scenario, partnership, if you're an unregistered partnership, you're allowed to set off only 100 rupees. Today, you and I might be laughing at 100 rupees set off. But imagine this was made in 1932. 100 rupees was a significant amount at that point of time. Are you with me? Understanding the point? So when you're reading the law, you have to interpret the law as if it would have been made at that point of time. First thing. Second thing, whatever circulars, clarification, press notes, whatever the various clarifications and notifications which the government is issuing, read it in line with the underlying law. Clear? This is about your contemporary exposition. Crystal clear with the concept, everyone? Yes.
Yes.
Next, after this, you have internal aids of interpretation. Highlight this, highlight this, highlight this. Write down internal aids of interpretation. One question will certainly be there in examination. One question will certainly be there in the examination. Can I begin? Yes,
sir.
no.
Yes, sir.
The first one is internal aids. So every chapter, every law has certain classification. They've been classified with a certain things to do. The first one could be a title. Title could be a long title or a short title. Each of the title, does it have any interpretational values? It may or it may not. Example, a long title may have some interpretational value, but a short title, you will not be able to understand anything out of it. Example, Companies Act 2013 is the long title. Short title is just the act. Everywhere, wherever we use the word act, that is nothing but the Companies Act 2013. Now, just reading the word act, will you be able to interpret the law? Nonsense. You need at least the entire name of the act. Only then you'll be able to make sense out of it. Are you with me? Second thing, preamble. What is the preamble? Preamble talks about the objective why this law has come into force. We've come across this topic of preamble under General Clauses Act as well. It's an important topic. Third one, every chapter has a heading. Does heading and title have any interpretational values? We classify all the sections under one bucket, and that's called heading. Do heading have interpretational values? May be used for interpretation, but not necessarily that it is going to add too much value. Marginal notes. Every section on the left side, usually left side, have something written on the left side against each section. That is called the marginal note. This is just to give one title to each section. It is to tell what that section is about. Does it have any value? Maybe not. All right. Definitional clauses. Every act will have one section which is talking about all the definitions. Example 2. 2 under the Companies Act all has the definitions which are applicable to the entire act. Why do I need this? Ensure that there is proper interpretation. I don't have to repeat it several times. Avoids shortening the language. This is the whole objective of having a definitional clause. Next, you have illustrations. Classic example, standards on auditing. All right, you go check your standards on auditing. You will find several illustrations which have been given. Does it have any interpretational value? Answer is yes. It can be used for the purpose of interpretation. Proviso and explanation. Two things that you will come across. Proviso is to carve out exceptions to the main law. Section 2, clause 71 defines the word public company. Public company means a company which is not a private company. Proviso says, however, a company which is a subsidiary of a public company, which by its articles of association may be a private company, however, for the purpose of this act will be a deemed public company. What am I doing? Through the proviso, I'm carving out exceptions. I'm qualifying. I'm withdrawing something from the main law. That is called proviso. Next, you have explanation. What are explanations? Explanations are to give more clarity on what the topic is being discussed. All right. It gives me a little more explanation on what and how things have to be done. It gives me a reason why lawmakers have done something. Classic example, Section 9. You open Section 9 of Income Tax Act. Every subsection has an explanation in it. Income Tax Act there in your syllabus, right?
Yes.
Sir.
Yes.
Section 9 done, business combination, business connection, royalty, fees for technical services, all that done.
Yes, sir.
Sir.
There's
Yes,
only
sir.
one batch going on, right? There are no parallelly two batches going on.
No, sir, only one batch.
No, sir.
Why do
Only one.
somebody is saying yes and somebody is saying no? I really don't understand. All right. Section 9 done, right? Business
It is
connection
done.
definition you might
Yes,
have
sir.
come across.
Done, sir.
Classic thing. All right. What is explanation there? Everything is to clarify what is the objective of the law. All right. What do they want to cover? That is an explanation. Schedules. Classic example. Your Schedule 3, Companies Act. What is it? It is a table which has been given to make the law clear. It is to give you formats. It's to give you rules. It's to give you details. It's to give you formats which you can use for the purpose of applying the law. Clear? This is your schedules. The last two words which you will come across often: without prejudice, notwithstanding, and subject to. Sit straight, everyone. Without prejudice means I am not affecting whatever has already been discussed. I'm not changing that. That will remain, but I'm giving you an alternative view. That is the meaning of the word without prejudice. When I use the word without prejudice, I am not affecting the generality of what I've already spoken. That will remain. In addition to that, I'm saying without prejudice. Classic example. Everyone sitting here have to focus during the class. Without prejudice to that, you can start making notes as well. What is the meaning of this? Everybody, general piece of law, everybody has to follow what we have said, focus during the classes. Without prejudice means without changing what I've already mentioned. That means that will remain. You have to focus during the class. Along with that, I give you an option of writing law as well. Clear? Everyone understood the meaning of the word without prejudice? Second thing which you come across is notwithstanding. One of the strongest languages which any law can use. All right. Notwithstanding is one of the strongest languages which any law can use. It's also called non-obstante clause. What is the meaning of this? The moment I use against any law, in any law, the moment I use the word notwithstanding, that means I don't care about anything else. This will follow. Sir, if there is anything inconsistent, that will be a waste piece of discussion. This will follow. This is the meaning of the word notwithstanding. The third word which you will come across is subject to. What is the meaning of the word subject to? What I'm saying is dependent on what is coming outside somewhere else. So when I'm saying subject to Shetty sir's availability, I will take classes. That means if Shetty sir is available, then he will take the classes. If Shetty sir is not available, then I will take the classes. The meaning of the word is subject to means dependent on something else. Crystal clear with all the three words. Everyone, please expect either of these in your examination. Write a short note. Read, one of you, start. Without prejudice.
An expression containing the words without prejudice to the generality of indicates that anything contained in the provision following such words is not intended to cut down the generality of the meaning of the preceding provision.
Next.
Meaning of the term notwithstanding. A provision containing the word notwithstanding is generally termed as non-obstante clause. The provision containing the word notwithstanding has an overriding effect on the other provision, that is, such provision shall prevail over the other provision. In other words, if there is any inconsistency or departure between the non-obstante clause and another provision, it is the non-obstante clause which will prevail. Accordingly, a non-obstante clause restricts the operation and effect of all the contrary provisions. Meaning of the term subject to. A provision containing the word subject to gives an overriding effect to the other provisions, that is, other provision shall prevail over such provision in case of any inconsistency.
Did you understand? In case of notwithstanding, this will override that. This will prevail over that. In case of subject to, that will be overriding or that will be prevailing over this. Crystal clear with the concept? With this, we are done with your interpretation of statute as well. All right. Can we quickly take one small topic as well and look at it? All right. Before I begin with your discussion on how to go about with this paper, I will just take one small topic as well. So I think we're done with prospectus as well as done. And the next topic is share capital, which we have to discuss yet. We haven't discussed it yet. All right. And then we have after this deposits. It's a simple chapter, small. Can I begin?
Yes, sir.
Yes.
Catch me if you can.
Yes.
All right. Section 73 is talking about prohibition on acceptance of deposit from public. Very, very important section. You have to remember word by word the definition of the word deposits. And what is not deposits is also equally important. Insist you to keep your cameras on and focus on the topic that we are discussing. I repeat, what is deposit and what is not deposit? Very, very crystal clear clarity has to be there when you're preparing for your examination, because from deposits, if they have to ask a question, then it could be revolving around the definition. Am I clear, everyone? All right. So what exactly do you mean by section 73 says you cannot accept deposits, all right, until and unless it is allowed. From public, though, you can't even think. Sir, private companies. Private companies can accept deposit from public. Deposits are more like loans, right?
Are
Even think about it. All right. Because there it is prohibition. And that prohibition is from securities, not only shares. Am I clear, everyone? All right. So going back to the topic, Inchara, section 73 is talking about this entire section is not applicable to banks and NBFCs. If you want to accept deposit, it has to be only if the conditions which have been prescribed here that are satisfied. Very important, whenever you're accepting deposit, you have to ensure that you're informing your daddy. Very, very important. Whenever you're accepting deposit, you must also create something called as deposit repayment reserve. Important topics being discussed here. Section 74 talks about repayment of deposits, etc. accepted before the commencement of this act might not be much relevant because the intermittent period which was given is shorter and it's done away with. Section 76 is talking about acceptance of deposit from public by certain companies. Note, not every company can go to the public and raise money. Only eligible public companies, or Satvik, only eligible companies can raise money from public. Now, what do you mean by eligible companies? Eligible companies means those companies which have a net worth of not less than 100 crores, turnover of 500 crores, prior consent of the company in the general meeting by special resolution, and you've informed your registrar that we are planning to go take money from the public. Only if these four conditions are satisfied, then you can go ahead and call yourself as an eligible company. So what if I'm an eligible company? You cannot go ahead and raise more than 25% of your paid up capital plus free reserves. It's very, very clear. Everyone with me? What are we talking about? Raising it from public. This is about raising it from public. Everyone. Next, the maximum period for which I can raise 36 months, minimum 6 months. Sir, I want it for shorter than 6 months. You cannot go ahead and accept it for shorter than 6 months unless and until there are other satisfied conditions. All right. A deposit can be repaid earlier than 6 months if deposits are not exceeding 10% of aggregate of paid up capital plus free reserves. Do you remember? I told you, don't play around in this chapter. Minimum 6 months. Sir, no, sir, I don't want 6 months. Then no problem. You reduce it. You pay it even before 6 months, but maximum deposits that you had taken itself is not more than 10%. Very important. Even if I'm reducing it from 6 months, it can't fall below 3 months. That means a minimum 3 months to rahega hi. Clear, everyone? Understood the point? All right. Next, government companies can go ahead and accept 35% of paid up capital plus reserves. A company cannot issue secure deposits until and unless a trustee is appointed. Company to maintain register of deposits, very important. If you default in paying your entire loan on interest, then there is, or deposits, there will be an interest of 18% per annum for your overdue deposits. Now, sit straight. What am I talking about is what is not deposits. Sit straight and listen to me very carefully. What is not deposits? Amount received from government, amount received from banks, any amount which has been received by any bank or as a loan, any amount which is received from a public financial institution, any amount which is received through a commercial paper or certificate of deposit, any amount which I received from another company, very important. Any amount which I received from another company is also not deposit. Any amount which is collected in the form of share application money is not deposit, provided I will give you 60 days. So within 60 days, either allot the shares, and if you cannot allot the shares, you have 15 days to refund the money. After 75th day, that share application money is also going to be considered as deposits. Aditya, there, can I continue? Any adjustments of the aforesaid amount will not be treated as refund. That means share application money cannot be adjusted against any debt. Shut up and repay it. You cannot adjust it against any other amount. Amount which is received from the directors of a company or a relative of a director of a private company will not be considered as deposit, provided they give a declaration that it is out of their own funds and it is not out of any public funds. Clear? Do you remember we had done a 2x2 matrix? Public company, private company. Director ka paisa can be for both public and private. Relative of director of a public company, of a private company, you cannot accept. That is not deposit. However, relative of director of a public company is not covered within this discussion. Clear, everyone? Understood the point? All right. So what are we discussing? We are discussing what is not deposits. Is the screen visible to everyone?
Yes.
Next.
Yes, sir.
Any secured charges are not deposit. Any amount which is non-convertible debentures which do not have a charge on the asset. Very simple. First point, Inchara, we are talking about if you have a secured charge, it is not deposit. But if it is unsecured debentures, even though it is not secured, I will still let you be not a deposit, provided it is listed on the stock exchange. Clear? We discussed this as well, if you recall. Next point. After this, any amount which you receive from an employee is not going to be deposit, provided that amount is as much as his annual salary. If it is more than his annual salary, that excess portion will be considered as a deposit. Next point. Non-interest bearing amounts which you have held in trust, not deposit. Any amount which you've received in the course of the business is not deposit. Any advances which you receive in the course of business, very, very important, very important topic. Any advances which you receive in the course of business, not deposit, provided you have given goods or services against that within 365 days. I have taken advance from you. What is the difference between loans and advances? Loan has to be repaid in cash. Advances have to be repaid in terms of goods and services. So if you have given advance to me, then I have to give you goods and services within 365 days. If I give it to you in return in the form of goods and services, it is not advance. It is not going to be considered as deposit. But if I fail to give this goods and services to you within 365 days, 100% that entire amount will be considered as deposits. If you're in a real estate business, 365 days will not make sense. Therefore, the amount has been extended to 3 years. All right, if it is in a real estate business. Next thing, security deposit which have been maintained for performance of contract is not deposit. Any advances for a long-term project is not deposit. Any consideration for warranty maintenance will not be a deposit, provided it is for absolutely 5 years, or whichever is the amount, whichever is less, that has to be considered. Any amount which you receive from sectoral regulators, not deposit. Subscription towards publication in print or electronic, not deposit. I'd given you an example of Netflix for this, if you remember. All right. So this is where we had discussed about Netflix subscription, which you pay for 2-3 years. Is that deposit? Law says no, it is not going to be considered as deposit, provided you have given the services in return. Next amount, any amount which is deemed to be deposit on the expiry of 15 days in case if you fail to refund the amount. Any amount which I'm accepting by a Nidhi company, any amount which is accepted by a chit fund company will not be considered as a deposit. Any amount which I'm raising it from an AIF mutual fund, all of that is not deposit. Very important. Open your ears, eyes, and listen to me. Tanika, any amount which I'm receiving in the form of a convertible note, 25 lakh rupees or more in a single tranche by a startup company, 4 conditions satisfied, then even that company will not be considering it as deposits. Even that amount will not be considered as deposits. Clear? Everyone understood the point? This is your entire definition revolving around deposits. Who can accept deposit? Only eligible company from public. Other companies can accept deposits only from members. They cannot go to the public. How much can they accept? They can go ahead and accept. Maximum is going to be 25% from public and 10% from members. If it is going to be government, 35% from public and members. If it is private company, 100% of paid up capital plus free reserves. If it is other than private company, 35% of paid up capital plus free reserves. Free reserves include securities premium here. Crystal clear, everyone? With this, we have covered 6 chapters of revision. All right, we have spent 1 hour 40 odd minutes. Just give me a quick minute and then we begin with how to prepare for this session, for the examination. Just give me a minute. I'll be back.
Yes, sir.
I'm here. I'm not going anywhere. Just allow me a minute. I'll sip some water and then we'll begin. Good to continue?
Yes, sir.
Yes.
The only question which I often get in emails, how to padai, how to go about with reading this subject. All right, many of them have asked this question. For the sake of everyone's comfort, I am dropping my email ID once again, just in case if somebody is stuck somewhere. All right, if you have doubts, which I might not have been able to clear it during the classes, although I endeavor to do it during the classes itself, but if it is not possible, I'm sharing this email ID. Reach out. If you have expectation within 24 hours, like a call center, if you will get a call back, don't even send an email. I will take my sweet time. There have been emails which I have to revert for almost a week. I will do it. I will do it. That's my assurance. You will get a reply. But if you're expecting within 24 hours, don't even drop an email. I will not reply to it. All right. You will get my response for sure. Doesn't mean that I'll respond after your exams. It will be duly taken care. I've been drop in the ocean, I would say experience, but that drop in the ocean, I will be able to manage. Don't worry. Coming back to the point now. How to study for this paper, I will share one quick screenshot, which I happened to come across in September 2024 material. Guys, for sitting in front of you for an hour or two, I spend hours of research and then sit with you guys. It's not going to be out of blue. All right. This is coming out of one weird document which nobody really opens. All right. And surprisingly, I happen to open that and I see ICAI has given their tips of how to prepare for this paper. All right. Which usually doesn't happen, but they've given their tips. Is the screen visible to everyone?
Yes, sir.
Yes, sir.
Yes. So these are the amendments which we will talk later on. All right. So this is what I'm talking about. First of all, do you know you get a student journal?
Yes, sir.
Yes.
How many of you opened it not to see the color and smell the print, but to actually see something beyond that? Only one person? You never know ICAI can do anything. Huh? Remember, ICAI can give important questions in that, and for all you know, those questions can be there in your examination. I was just toggling screens and I come across there's something called a put down your hands. There's something called as Saramsh on your ICAI website, which is called the last mile referencer.
Yes, sir.
Beautiful document. All right. I go through documents and that's why I can talk about it. All right. So this Saransh is also a very good document. If time permits, instead of seeing YouTube, instead of scrolling through Instagram, 100 new reels that you would see and forward it to 100 different people who are not even going to bother replying to you, might as well just spend time on seeing what is there on ICAI's website. Interesting document, very, very well drafted. This was some 2024 student journal. All right, September 2024 student journal, where ICAI has given suggestions for how should student prepare for exams in corporate law. I put the screenshot. This material will be circulated with you guys as well. Don't worry. And in this material, I will read it out. I'll spend enough time on this screenshot. What is ICAI's expectation from you guys is what we are talking about. Can I begin?
Yes, sir.
Yes, sir.
Yes.
Listen to me. I know it's there on the screen. You can read it. You should have read it long back, even before I put it up here. But now that you've not read, listen to me, right? Students should know how to handle and answer these questions for scoring good marks. While attempting practical or application-oriented questions, students should be able to pinpoint the legal points or issues involved in every statement, problem, situation given in the question. What is the requirement from ICAI side right now? Sit straight, everyone. Sit straight, everyone. Close all your books. Sit straight. ICAI's requirement is very simple. They don't want you to give me a 30,000 feet level GAN. All right. They want you to legal pinpoints. They have clearly mentioned pinpoint the legal arguments and issues. That means the requirement is very clear. You should know which section where things are coming from. First point. Are you with me, everyone? Understanding? All right. If you give 30,000 feet level GAN, if it was CA foundation, I would have accepted. CA final, CA inter, if you are really thinking you will give them some answer and come back home, you will not get marks for it. Clearly mentioned here. All right. CA inter, to an extent, still they could be liberal. CA final, don't even think about it. CA final, some other day, some other faculty will take you through. Right now, CA inter. I am very clear. Each one of you have to make last page notes of all the section numbers. How you do it, when you do it, sir, I've never got a chance to do it now. If you've never done it, do it. Simple as that. All right. So what do I write in that? Section number, what that section is all about. That's it. I don't want you to write the entire section. That's not the objective. I just want you to write what the section is all about. With me, everyone understanding the point? Meticulously do it for at least next 3-4 months. Every day in the morning, 10 minutes, you're going to see those sections. Now, sir, I have done it in my phone. I've done it on my laptop. Throw it aside. Neither you will have time nor that computer is going to prompt you every now and then to look at it. Might as well just write it on a piece of paper, stick it on the wall every day in the morning, meticulously, just how religiously you would want to do something, do it this one as well. Next 4 months, your only religion is CA inter results, which is pass and pass. Nothing beyond that can be your religion. I am secular enough, but at the end of the day, for me, this is more important. Please note, all the things will fall apart if you cannot clear the examinations. A lot of people have a lot of their expectations of life tied up with you. I'm not bothered about those. I'm very much interested in my expectation tied up with you. All right. And my expectation is all to see that pass and pass. Do you see a rank holder in yourself? Do I see a rank holder in yourself? 100% yes. Am I talking about that one person who usually answers during the classes? Am I talking about that one person who usually sends me emails? Am I talking about that one person who is asking the fancy ideas and fancy thoughts and fancy questions? No. I'm talking about that quiet person who is listening to me for all the 2 hours that I'm sitting in the session with all their due diligence. Ask yourself every time when there is a question in your mind, can I get a rank? The first immediate answer which you're giving, rank nahi aayega yaar. Rank and all is not made for me. I am not made for rank. If this is your thought, trust me, you shouldn't even be writing examination. Don't live a mediocre life. Trust me, don't live a mediocre life. There are many people who are living that life. Let them live. You're not made for a mediocre job. You are not made for a mediocre job. If you really want to do mediocre stuff, you should have just done BCom. You would have ended up with a mediocre lifestyle as well. If you're sitting here, push yourself a little more. When you were in your 10th, you never asked yourself, will I be able to get 96? Will I be able to get 98? Why? At that time, it was all possible. For all you know, that was the first examination which is supposed to be corrected at the center and state level. If you realize, those of you who've written ICSE, your questions would have gone, your answer scripts went all the way to Delhi. Your question papers were coming from Delhi. Am I making sense? Everyone with me? Ask the right question, you get the right answer. Your questions are stupid, you will live in stupidity. Simple as that. Why cannot I target for a rank? My examination is in May. I still have 120 days. Can I turn around my fortune? Answer is yes. It's just that I am lazy. I want that comfort coming in home every now and then, sleeping for 5 hours, 8 hours, 12 hours. Nothing will happen. You will come back, attend the same session, me giving you the same gyan, not useful. Ask yourself, are you ready to put in hard work? Yes, please proceed. I go back to the topic. ICAI's first point, please note, it says it needs legal answers. That means verbatim language from your study material is very, very important. So how do I study now? The question is, please read your study material. I have made your CAPS material. I am telling you authoritatively, I have not copy pasted study material. If that was the objective, I would have just given the study material copy itself to you. That is not what I've done. I've summarized, I've given examples, I've made charts. That is to ensure that you have one material one day before examination. That was the whole objective. I didn't want you to have 3 modules in your hand thinking about which one shall I select first. No, one single book which captures everything. That was the whole objective of coming up with the CAPS material. How do I study? Study material first, CAPS material immediately after that. Finishing both of these, I go solve RTPs and MTPs. I'm not going to wait for that golden day, which will never come in my life. It's today. I finish study material, CAPS material, RTPs immediately. How many RTPs? You have 120 days. You have sufficient time. You can finish at least 4 RTPs apart from your own. Sir, but we'll have to take printout, online copy. What should I do? Don't ask stupid questions. The universe will genuinely throw stupid answers on your face. Take printout. Each one of you sitting here can afford a copy of printout for sure. Nobody is running short of money to the extent where you have to think twice whether I have to take a printout or not. Worst case, if those are the days in your life, use the soft copy which is available on the website. Simple as that. 4 attempt RTPs mandatory. I'm still telling you, I have seen question papers with RTP questions. I can name the person if required. All right. Harshvardhan, AIR 14. I am telling you the name with the All India rank level. In his pass out meet, no exaggeration, go pick it up from YouTube. In his pass out meet, 14 marks, accounts paper, questions came from mock papers and RTPs. He made this statement with numbers. Copy, paste. Am I making sense? Everyone with me? Are you guys okay if I can just extend by another 5 minutes? Is that okay
Yes,
with
sir.
everyone?
Yes, sir.
Yes,
Yes.
sir.
Yes,
All right.
sir.
So Second thing, presenting. All right. How do they want you to answer the application oriented question? How do you answer it? What are application oriented questions? Case studies, which we saw. All right. In those case studies itself, they're asking, how do you present it? Heading, if possible. Relevant provision with correct section numbers and correct name of the act with year. I hope I'm clear what ICAI is looking at. They are not looking at only the name of the act without a year. They are also looking for the section number. So next time, if you ask this question, are section numbers important? Should I memorize? Answer is here. It is necessary. Next, facts of the case, correlation of the legal provisions, and conclusion. In simple terms, what you are already following a pattern. Facts of the case, provision of law, analysis, conclusion. Beautiful pattern. Let's continue with that. But the answer which you are looking for, should I know the section number? Should I know the answers? Do I have to look into subsection numbers? It's categorically mentioned. You have to. Please keep your cameras on. Listen to me very carefully. Language, one of the biggest problems in law. Read, one of you.
This is an important area of concern and advice for the students.
Hold. ICAI itself is clearly saying it's an important area of concern and advice to the students. What is the requirement? A prevalent observation is that many students, while proficient in the subject matter, exhibit weakness in the English language. What are they saying? You're giving Gyan. That Gyan is correct. But the only problem is that Gyan looks like more like you're talking to your friend than writing an answer in a national level examination. Am I making sense? Everyone with me? All right, guys. So those of you who are complaining, sir, I come from a rural background, I'm not able to pick up language, all that. Puck up. 120 days. Read, revise, read, revise, read, revise. That's the only thing which you can do. I was not born proficient with language in English. I don't even come from, none of us come from an English speaking background. All right. None of our parents would have spoken to us in English when we were in kids or even now. It's obvious. We don't know English. It's very natural. All right. But doesn't mean that I give that as an excuse forever. I have to pick it up. 120 days you do anything under the sky, but your language has to be proficient. It has to be in sync with ICAI's material. That's it. Nothing else. Am I making sense? Everyone with me? Yes. So please ensure that you are spending enough time. The only way to remember is revising. Even today, if I have to sit with you guys, I do not sit in any of the sessions without looking at my subject once again. It's been decent time. I would still say a drop in the ocean, but a decent time, more than half a decade that I've been teaching this subject. Still, I look at the topic and then sit. I would say Shetty sir has been teaching for 25 odd years. Still, he looks at the subject and enter the sessions. All of us have to do it. Revision is the only way you remember. I'm sure each one of you would have observed I don't start any of my sessions without revision. Reason being very simple. Only when you catch up on what has been taught, you will be able to understand what I'm going to teach. There, everyone. All right. So those of you who are complaining, sir, I'm not able to read properly, revise that properly, you will be able to write. Simple as that. Understanding? Next. The next topic is consequently their answer presentation often lacks appropriateness. This challenge among numerous candidates can only be addressed. Open your eyes. How do you address? ICAI is giving you solution as well. Through consistent writing practice and self-assessment. All those of you taking the test casually, today morning itself, you could see 6-7 of you had raised your hands. I respect the fact that you've been honest, guys. But at the end of the day, what's the use of that honesty when you're not serving yourself? 1 week you don't write the test. And those questions are all tricky questions that I'm giving. Those questions are all coming from examinations. You're not writing. And then we complain that, sir, law is a theory paper. I'm not able to write. You're not able to write because you've never written. Given an opportunity where you still don't write. So next time when you have a reason for not writing a test, ask yourself, why are you not doing it? Are you going to do it really once again in the examination after another attempt? Ask yourself. Next, by studying corporate and other laws with a rational and objective mindset, you can not only achieve success in your exams, but also make a significant contribution to the legal and corporate sector as a future chartered accountant. I'll not spend much time on this. Simple, guys. Please spend some time on getting your language right. All right. How many tests have I conducted? 6.
6
right?
completed, and today we have written the
The
seventh.
seventh one,
Yes,
right?
sir.
7 tests I myself held up. All right. I have held 7 tests. If you've not written 7, first thing that you got to go check in the mirror. Do you really deserve clearing CA in the immediate attempt? 7 tests. All right. Second thing, worst case, chalo, I wouldn't have been able to write it back then. Did I at least make effort in writing it later on? If no is your answer, 100% hand held on heart, I'm telling you, not fit for this examination. Don't write CA examination, write something else. All right. Because after 7 times, not even picking up that initiative of writing it, when do you think you will do it? I'll leave it to you. What I can say is, please note this 120 days which you have. All right. I'm still counting only 120 days, because out of that 120 days, also 10 days will go in some 100 things which you have lined up with. All right. Some 12 students, some BCom graduation, some nonsense lined up, 100 things which you will have. Not keeping well, not answering, blah, 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 blah. 120 days, 8 subjects. You don't even have enough time to look at each subject twice. If each subject you're spending 10 days, you still don't even have enough time to look at the same subject twice. This is the time period which you're sitting with. Do you still want to sit, daydream, count stars? Left to you. I happen to meet some saint, all right? Good, bad, don't bother about it, all right? So I was with my mom, and very interesting. My mom did mention that I'm sitting for hours together, but I'm not able to focus when I'm meditating. All right. It could be whatever the practice is. Let's suppose she's chanting some names or whatever it is. All right. That saint said something very profound, very interesting. Things happen in 3 stages. First, you sit. Second, you talk about it. You start doing it. Third, in reality, it happens. All right. All those of you sitting here who have this complaint, sir, I'm not able to focus. How long have you even sat to focus? 40 minutes, 50 minutes, and then concluded that I'm not able to focus? Sit for 10 hours. And then if you say that I'm not able to focus for more than 1 hour, that is an appreciable fact that I can even understand. You sit for 40 minutes and you want to focus for 400 hours in that 40 minutes. Not possible. We have not been trained. Neither we are superhumans. So very interesting, the statement that Saint said, which hit me so hard. And I seriously think about it. All those of you students who have sent emails to me, sir, personally I have this, personally I have that, personally I'm not able to focus, all that, whoever it is, XYZ, all right? They sit first, sit for 10 hours, focus for 2 hours. That 2 will become 4, that 4 will become 8, that 8 will eventually become 10. Do you think one day before exam, will you be in a position to complain that I'm not able to focus? One day before exam, you wouldn't. Then why are you complaining now? You first sit at least. You're not even sitting for 40 minutes and you have problems of not being able to focus at all. That doesn't make sense. Next 120 days, each one of you have to make it somehow 10 hours of effective studies. Sir, 10 hours, how will I do? Look at your faces. A lot of you are raising your eyebrows. Guys, you have to sit for 10 hours, or else you'll not be able to finish the syllabus. Are you able to understand what we are talking about? The gravity is extremely high right now. All right. I repeat, 120 days. Even if you sit for 120 days, 10 hours each, still we are covering only 1200 hours. 8 subjects. It still appears to be close to impossible. All right. In that, don't forget, you will fall sick sometime. You will not have mood. You will not have interest. Pull up your socks. You're running short of time. If you haven't made a timetable so far, okay, make it today. So tomorrow morning, 6:45 class, I'll finish it and then I'll make timetable. That tomorrow will not come. If it is tomorrow, ensure that you're planning to write another attempt again. If it is not happening today, it is going to be another attempt which you're planning for. I'm very clear. Next, one suggestion, guys. Please find one among this whole circle of 44 people. It's a one person who's going to be your point of contact, to whom you're going to reach out and talk about your worries, to whom you're going to vent out whether you're able to study or not. And let's be honest to that person at least. You might not want to be honest to the entire world, but at least that one person you have to be honest. You study and tell that I'm not studying and all that nonsense which we can do. Don't do all that. All right. To that one person, let's be fair enough, because you're there for pushing each other. This whole concept of Shetty sir's Edu Buddy and all that which he propagates, which he proposes, is a very effective tool. I myself am in still touch with that partner of mine, all right, with whom I used to study. We still talk about profession today, but we are still in touch talking about things, and we are still being fair enough in our conversations. Find that one person in this group. Can it be an outsider? Answer is no. Sir, who is that person? You will have to make efforts. I'm not going to make couples for you. All right. You have to do that. Am I clear? Everyone making sense? Now, who's that one person? You have to find out. Can that one person itself become a partner for 10 different people? That one person is doing injustice to 10 and to himself. Please be very clear. One person is what I tag along with. I'm not going to tag along with 100 people. If somebody calls you after being tagged along, please clearly say, I've already tagged along. Maybe next time, in case if there's something lined up, I will keep you posted. Simple. Finish. Am I making sense? Everyone with me? All right. Please do it today. Tomorrow morning will not come. Tomorrow morning is another attempt which you're going to plan after May. If you're waiting till tomorrow morning, this is not your attempt. It's going to be the next attempt itself. If you can't do it today. What am I going to discuss with that one person, sir? Am I going to discuss about life? No. That Gyan after clearing. You should have some credentials to talk about life, right? So add that credential and then talk about life. The only point is you're going to discuss what is our strategic plan to go about with this subject, that subject. Every day, we are going to spend 10 minutes in revising our section numbers, be it in Companies Act, Income Tax Act, be it in SA numbers, be it accounting standard numbers. I leave it to you. Do that. Do that. You just have 120 days. Go mad about your efforts. This exactly 4 months is what I had got during my CA final. Today, when I'm sitting with you, this is exactly 4 months that I'd got during my CA final. You have similar time frame. See what is the best that you can do. Do justice to the efforts which you might be putting, but you're putting for your selfish intent. Somebody else is putting for you. And that's none other than your parents. Please do justice to that. All right. While you're sitting here peacefully listening to me, somebody else is toiling there. All right. Somebody else is putting in extra sweat just so that you can peacefully sit here. Let's respect that. Let's not go down to docks where we become inhuman. That's not what we are, right? So I have taken way more than the time given. I hope I have done justice in the 2 hours that we've spent together. We have covered 6 chapters, effectively 6 chapters, section by section. So I'm glad about it. Please put in your timetables. Please start working towards your subject, towards your goals. You're stuck somewhere where you feel that somebody has to help me. I'm just not out of that position. Feel free to drop an email. Only if you are really stuck, I will also revert with my number and I will talk to you if situation really needs, or else I'm not going to bother doing anything. Of course, that push, that motivation and all that which you require, I will be there around. You don't need my motivation. Your people around you are motivating you. Your parents must be motivating you. People around you, that in itself should be such a huge energy for you to start kicking in yourself. Last thing, please put in efforts. I will be finishing the syllabus soon. All right. I am left with very few chapters in your syllabus. One is going to be the auditors, companies incorporated outside India, LLP, FEMA, and share capital. That's it. I'm done with your syllabus as well. Ask yourself, where are you? All right. With this, I wrap up. Thank you so much. Have a nice day, guys, and see you in tomorrow's session.
Thank you.